Good morning, everybody. This is Marty from Dogs Blog with a noontime report. It's not the morning session of the Frank Carson trial because they're doing a pitches motions in regards to Scott MacFarlane and Eduardo Quintanar trying to get their records from when they did the internal affairs investigation on them, which subsequently ended up being they were terminated from the CHP. The DA is kind of on a fishing expedition to try to get some of that information. These statements have been paid, and they do have protections under the police officer's Bill of Rights, and the DA is trying to circumvent that. And so scheduled this morning for 9 o'clock. And 9:22, the judge was on the bench. Larry Niemeyer, representing Scott MacFarlane, was here. Alonzo Bradford, representing Eddie Quintanar. The Attorney General was here, and I didn't catch his name. And Marlissa Ferrer was representing the people. Judge Aniga said she has read all the briefs, and she said, to Marlissa Ferrer, this is your motion. Go ahead. And she says the basis before them is the information in the statements that were made during the internal affairs investigation of the CHP for both officers. The statements are needed for the Frank Carson case, as they will be witnesses in this case, and that may contain Brady information that they are required to cross-examine, to provide to the defense so they can properly cross-examine these witnesses. Judge Aniga noted in the Attorney General's brief that they say the request is very broad. Marlissa Ferrer said the DA's office focus is on the investigation of officers and any discipline for each in regards to conduct on those officers prior and during this investigation. They believe there was prior issues due to information in the wiretap, so they think something was going on. They don't know what, apparently, and it's kind of in a fishing expedition. It's not very clear. Judge Aniga also noted that the first order, or the first request that was filed, was they were asking for compelling statements. Now it's a pitches motion, so they've changed their direction on this. The first filing wasn't allowed because there was some procedurally wrong with that, and now they're changing it to a pitches motion. And what the DA submitted, it was not proper in the filed civil sections cited in the filing. They have no merit in a criminal case, or in the Carson case. I believe she said it was the government code that was cited applies only to civil cases. Marlissa Ferrer says they're still looking for compelled statements of the officers. They are compelled to seek this information based on Brady information, and the information could be exculpating information of any misconduct or issues with the officers. Judge Aniga says the DA is asking the court to incorporate the original filing and this motion incorporated together based on her argument. Marlissa Ferreira says they have to incorporate both of these motions kind of together, as well as the new information. She says, I don't think so. Judge Aniga said, I don't think so. The AG, and I do apologize for not getting his name. It was hard to hear everybody. They weren't using the microphones. The AG objects to the government code claim. It's 3330 or something, 3303 I think it was. And there's also the police officer Bill of Rights that they prohibit some of these information being dispersed. he's not aware of being of the new arguments that are now being made by the DA in her oral motion that she is making. Larry Niemeyer objects the first time. He says, I also object now. Alonzo Granford says the same thing. Marlissa Ferreira argued to the court again, if the court's not going to cooperate or comply or give the DA the ability, she's asking her to at least do an in-camera review and see any issues unfiled to determine that the court has discretion. So again, she doesn't know. She's going on a fishing expedition. Judge Iniga noted that the Pitchess motions are procedurally driven. There's no question of litigation that's going on with the defendants and the county, and it could be just a fishing expedition for other things other than the Frank Carson case. Marlissa Ferrer said it's very difficult to be specific if not known what's in the file. That's the whole point. On the wiretap, the officers were giving out police tactics to the defendants, and Scott MacFarlane was giving out information of seeing Corey Coffin afterwards after the theory date that they had developed. And for anybody that may not know, their theory date is the family says Corey Coffin disappeared on March 29th. The investigators saying he disappeared on March 30th. Scott MacFarlane said he saw Corey Kaufman April 1st, riding his bike down the street by his house. Judge Iniga says that she knows that Marlissa Ferreira is between a rock and a hard place on this. The upper courts have ruled even the district attorneys have to comply with procedural precautions, proper procedures to get some of this information. Attorney General also again argued it appears that they are not specific for their reasons or causes, and it should be denied. He objects to any prior motions and current motions aware of the Scott MacFarlane agreement. Scott MacFarlane has agreed to testify in his charges being dropped for his testimony in this case, but not complete. The case is not complete. He is still technically a defendant until he testifies and completes his agreement. He's also was not aware of the immunity agreement that Scott MacFarlane and Quintanar have for their testimony, and they have both lost their job, but does not necessarily mean anything towards this motion. The defense needs to file their own motion for the information, not the district attorney. No showing for good cause has been made by the district attorney themselves. He said that every party has to make their own motion. It cannot be turned over to any other party, so the DA request is not proper. Larry Meyer said that the declaration that was filed by the district attorney's office is insufficient because Scott MacFarlane does have some exposure until he actually completes his testimony. So he just wanted to make that clear. Attorney General office submitted. Marlissa Ferreira argued the court has invited all parties to the Pitchess motion. The defense chose not to join or engage in this motion. But they do have, it does have relevant obligations. They have an obligation to supply discovery evidence to the defense to establish that a fair trial has been had. Scott MacFarlane now as a witness requires her to supply discovery of Brady to defendants. Defense has due process rights to the information. Quintanar not a defendant anymore, so no standing as a defendant in this case. procedure is due process rights, as both Scott MacFarlane and Quintanar rights are not outweighed by the basis of a fair trial for Frank Carson, Baljeet Atwal, and Daljeet Atwal. The reason that they want the information does not change the obligation they have for due process rights of the defendants to be able to get this any information available. So what she's saying that she's trying to get this information for the defendant's behalf. Marlissa Ferrer said her Brady obligations say that she and the judge have a duty to provide this information, even if it's from a defendant. She said, have an obligation to provide this information, period, if the defense has shrugged their responsibilities of their duties towards these defendants and these witnesses in the case. Is still her responsibility to get the information for them. This is a necessity to conduct a fair trial. This is Marlissa Ferrer talking. This is a necessity to conduct a fair trial for the defense. The defense are talking about bad behavior in the DA's office, and Scott MacFarlane has agreed to testify. Quintanar may be different. The DA didn't know what the statements are, so she cannot specify anymore. She doesn't know what's in these files, but she says for the defendant's behalf that she can go fishing for this information. Judge Aniga said, and here we go, the argument she just made should have been in her moving papers, but she did not. Marlissa Ferrer says, well, I'm articulating it now. We can join in my oral arguments to those moving papers. The Attorney General says the argument I just heard is what is expected you would write, but it was not, so this had not be heard at this time because they haven't had time to prepare. Marlissa Ferrer again said that she just wants to incorporate it into her argument because she saw a positive response from Judge Aniga. Judge Aniga said the police officer's Bill of Rights is very specific, and what the defense attorneys can do and can't do is sometimes different than what applies to the DA. So she may not be able to turn over some of this information otherwise, but it still benefits the district attorney's office. Again, she started talking about procedure and the proper procedure issues and understanding all the concerns over discovery. In this case, the DA is trying to comply. The DA has concern that the defense could argue the DA doesn't make the proper effort to provide the discovery, and they've been arguing that all along. Judge Aniga is getting that confused look on her face, I wrote it down, and saying it is multi-layered. She didn't really know what to do. She told her if she had made the argument that she just orated in court in her brief, that she would grant it. But there has been a proper objection to her argument, and she is denying the motion without prejudice, meaning she can refile the case, or refile the motion, anytime, and she's took the attorneys into chambers. I knew something was up. So this is about a little after 10, around 10:15. They announced that the court was in recess, and the Judge Aniga gave Marlissa Ferrer until 11 a.m. to amend her motion to include her oral argument. The court in recess until 11 a.m. And also note too that Judge Aniga was talking with Marlissa Ferrer, and again, as she's done many times, given her legal advice and what she needs to put in her new emotion that she's allowing her to do for the third time. And then they went into recess until 11 o'clock, and Marlissa Farah headed back to her office. At 11 o'clock, Marlissa Farah was not there, and the bailiff was trying to contact her, and then she finally got a hold of her around 11:17, said she's 3 minutes away, she's probably walking over with it, and she did arrive at 11:20. Judge Zuniga read the motion in chambers. Apparently, Marlissa Farah filed separate motions in regards to Scott MacFarlane and Quintanar, so there was a separate motion for each one. The DA refiled the motion and changed her declaration of paragraphs number 8 through 12. And so the DA, she says, it's your motion, ma'am. She let the DA argue again. She says, Marlissa Farah said, basically, this is what the people are asking. What the investigation into the internal affairs investigation and whatever information's in there. She says that Scott MacFarlane and Quintanar made false statements during the internal affairs investigation due to the information on the wiretaps, is how they determined that. The witnesses were involved in efforts to obstruct justice, also made false statements of relationships and false statements of defense of the defendants. I'm sorry, not defense, the defendants. The termination of the CHP officers goes to a veracity and the moral character of those officers and why they were fired. Also, keeping firearms at Pop and Cork shows issues with the defendants, mostly lacking character. They did impede this investigation with false statements. Any impeachable information of the IA investigation is critical to credibility. DA's office has an obligation to provide that information, and it outweighs any privilege right that the officers may have, or now witnesses may have. Again, the Attorney General objection under the same reasons and arguments that he gave before. The DA has not made good showing with all the issues, and it should be denied. Alonzo Granford objected to the motion also, the motion standing, also the timing of the motion, as he's not allowed to prepare a proper response by giving her 45 minutes to go rewrite the motion and coming back and making a ruling. So he's not able to look into it further and formulate a proper response as is typically normally done. Marlissa Farah said they have not provided any real new information, and it could be argued orally. No need to reschedule to do a response. Judge Zuniga started saying the Attorney General is really in the lead in this opposition to this motion. Larry Niemeyer, who is having Alonzo Gradford sit in for him at this section of the hearing, noted that the Pitch's motion is not the proper way to get this done. Being asked to respond to new information as the issue is too broad. The motion to continue the hearing is denied. The DA finally articulated earlier in her argument, so is now not so broad. And as she is saying that she agrees that the witnesses are the DA information that she's looking for that goes to the witness credibility, things like guns and pop and cork and the wiretap information. The DA has given a very narrow argument. Judge Zuniga said it is only for information in regards to the Carson case and the Carson case only. Judge Zuniga is going in camera with the files. She agrees with the Attorney General. The DA is not entitled to some of the information that cannot be turned over to defense attorneys. So not everything that she gets can be turned over to defense attorneys. And so her argument for the defense, doing it for the better interest of the defense, is not really credible. They may have to do a pitches motion themselves. But Brady information must be disclosed. So that was it for the morning session. Judge Zuniga, Marlissa Ferreira, has twice not filed the proper motion. And so after talking to the judge, and she tweaks her argument like she always does, and she finally gets the judge to agree to it after being allowed to rewrite the motion for a third time. They're going back at 1:15. She's going to determine the other thing with the argument the AG made, so it may not go to the DA anyway, because the judge was rethinking her comment earlier about if she would approve the motion if she had made that argument in the brief. So we're going back at 1:15, and then they're doing some other things this afternoon. I will see what happens this afternoon and then make a determination if there's a podcast tonight.